Welcome back to Rationally Based, a podcast about law and politics on the edge. Kathryn, what are we talking about today?
Well, there's a lot to cover. We are starting with a legal lightning round, where we'll talk about the secrecy at the Supreme Court, the recent decision in favor of Trump's DEI ban, the SAVE Act, and a ruling in California on mask bans for ICE agents. Then some huge news in the immigration world. The Fifth Circuit has ruled that the Trump administration can detain all aliens who have come to the country illegally pending removal proceedings. We'll break that down. And finally, we will get to birthright citizenship. The Supreme Court will hear oral arguments on April 1st. This will be the first of several discussions in which we dive into whether or not the conventional wisdom on this topic is right or wrong.
Let's dive in.
I'm your host, Ilan Wurman, a law professor at the University of Minnesota Law School.
I'm Grace Keating with Center of the American Experiment.
And I'm Kathryn Johnson, also with Center of the American Experiment.
Where should we start today?
Such a good question. Well, another legal story came out of the New York Times last week. It was titled, How the Supreme Court Made Itself Even More Secretive. Apparently the Chief Justice...
That was a little editorial, but...
Here
yeah,
we go.
Right.
Another New York Times hit piece. Okay, sorry, Kathryn. What does it say?
Apparently, the Chief Justice has imposed a formal non-disclosure agreement upon all the employees and law clerks, which is ironic because, we found out about it through the New York Times. So apparently, there was no non-disclosure on the non-disclosure agreement itself.
That's a fair point.
This follows on the heels of the infamous leak of the draft of the Dobbs opinion overturning Roe v. Wade, which we all remember. And a recent New York Times piece detailing behind-the-scenes decision-making in the Trump immunity case. So, Ilan, why should we care about this? Why should we know the inner workings of the court?
We shouldn't.
Oh.
Who cares? Another New York Times hit piece. I mean, let me say a few things about this. The Supreme Court is, of the three branches of government, the most transparent in a very important way. It's the only institution that has to provide public-facing reasons for a lot of things that it does. Now, of course, the president and the administrative state, they have to provide public-facing reasons when they make regulations and things like that. Congress doesn't really have to make any public-facing reasons. But the Supreme Court, we know it's argued to them. The briefs are public. Oral argument is public. The justices' questions are public, and their opinions are public. So if their opinions are wrong, then tell us why they're wrong. Of course, justices are political. We know that. So what will the secret inner workings tell us that we don't already know, right? So they already have to file financial disclosures as well. I'm not sure if most people know that. So that's how we know that, I think, again, Justice Alito, who I feel like we mention every episode on this podcast, has oil stocks. And so he has to recuse when he hears a case involving, Chevron or whatever. And that's fine. But what good does it do to learn more about the secret inner workings of the Supreme Court? Their reasonings are the reasonings. The law is the law. And you could argue about that. So, for example, there's a hit piece on Justice Thomas, whom the conservatives love. He's probably the most dependable originalist on the court, saying, he's gone on all these trips with his billionaire friend, Harlan Crow, and how improper. Give me a single Justice Clarence Thomas opinion where you think he ruled otherwise than how he might have ruled because of his relationship with Harlan Crow. It's preposterous. It's public facing. That's all we really need to know.
They did that with his wife too, by the way, who it's like, what, is your wife not allowed to have political opinions if you're a Supreme Court justice? That's basically what they insinuated.
Yeah, and so yes, your wife has opinions. Your wife has a appeal to heaven flag, if it's a Semolito.
Or your wife sounds based.
Yeah, she sounds great. Or you go to the Grammys. I'm going to dig into this. This will be a theme today of judges being political. I'm actually okay. You're human. Go to the Grammys, but leave it out of your opinions. As long as you leave it out of your opinions, that's fine. We can analyze your reasoning. And this is nothing more than just a New York Times hit piece. So again, if you look at the piece, it says the confidence in the Supreme Court is at historic lows. The court's reputation is battered. I wonder why.
Yeah, maybe if you stopped putting out hit pieces on the court, that would influence public opinion. I don't know.
Thank you. The court is in the hands of originalist judges whom you don't like. And so it is your mission to make their reputation as battered as possible. And there's nothing to be gained, in my view, from having, more leaks from the Supreme Court in this regard. And so forget the New York Times. Nonsense. Ignore them.
Is this unprecedented? Have we ever, I'm almost surprised that we have not had a non-disclosure agreement on the Supreme Court of all places before.
From my understanding, it was more a matter of informal practices. It's understood. I was a law clerk, not at the Supreme Court. on the Fifth Circuit, not to these judges who decided the case that we'll be talking about today, but another judge who, has a little bit of a reputation for being a bit of a firebrand. And the answer was like, we just knew you are not supposed to talk about the inner workings of the court. You're not supposed to talk about the cases that you worked on and so on. And it's just this unspoken customary rule. Law can come from custom too, not just non-disclosure agreements.
And clearly they've instituted this new policy because there were multiple leaks. There was a problem and they have to solve it. Getting outraged over this seems unfair to me.
Yeah, that's right. The New York Times just wants more leaks so it could do more hit pieces on the Trump immunity decision. But again, you read the Trump immunity op-ed that they had about, Chief Justice Roberts circulated a memo explaining that. Okay, he explained his view of what the law should be, and then he explained it in a public opinion.
Mm-hmm. I'm horrified.
Yeah. Why should I be outraged? All right, New York Times, forget you. Next.
The next issue on our legal lightning round, is the Fourth Circuit's ruling on DEI. So this is typically a more liberal circuit, is my understanding, at least in recent years. And they've just ruled in favor of Trump's anti-DEI actions. And there's something odd that the judge did in his explanation of his ruling. Can you walk us through that, Ilan?
Yeah, so the judge concurred to his own opinion, which...
That's so cool, by the way. I concur to all of my own opinions.
So some people do this. There's a kind of a legitimate role for concurring opinions to your own opinions. I mean, okay, normally what are concurrences? Normally, if you agree with the result that the court is reaching, but you have different reasoning than the judges in the majority, you can write a concurring opinion.
Okay.
Rarely you can concur with yourself. Sometimes this happens when a judge or a court says, okay, this is squarely foreclosed by the Supreme Court. I'm going to faithfully apply Supreme Court precedent, but I'm going to separately concur to explain why I think the Supreme Court precedent is wrong. So it's like a signal mechanism.
Oh, interesting.
But that's not what happened here. That's not what happened here.
Okay.
So it was just a political cry, if you will, in the concurrence. The concurring opinion was like, I'm so sorry I had to follow the law. And so I apologize to all my liberal friends. So so the DEI thing, I mean, this case was borderline frivolous. Okay, this is about whether the government can spend money, can give grants under certain conditions. So under the Biden administration, they specifically gave grants to things and people and organizations and programs that promoted DEI, right? Diversity, equity, and inclusion. And the Trump administration said, we're not going to do that anymore. Actually, we're not going to give you grants if you do this. So you must not have a DEI program, and it must not be a DEI a policy in place. If
you must not be racist.
That's the view of
you must not discriminate on the basis of race.
That exactly is the position of the administration. And a bunch of these states' attorney general, these Democratic state attorneys general, including Minnesota's, so lots of really fancy states and attorneys general and lawyers filed a lawsuit saying
calling Keith Ellison fancy was not on my bingo card for this morning. Go on.
Well, but yeah, okay, there are good people in some of these states' attorneys general's office, but this lawsuit was borderline frivolous. They said it violates the First Amendment. Wait, what? So if it doesn't violate the First Amendment to require DEI to get grants, how can it possibly violate the First Amendment to say we're not going to fund DEI?
It is wild.
It is totally asymmetrical. It is totally insane. So the lawsuit was, in my view, borderline sanctionable. And so even the liberal Fourth Circuit, which people say is like the new Ninth Circuit, it's before your time. But when I was growing up, the Ninth Circuit was super liberal, California, Oregon, Hawaii.
Okay. Makes sense.
And now it's much more balanced. The Fourth Circuit it has a big loss rate at the Supreme Court because their opinions are so liberal. And historically, the Ninth Circuit was in that position. But so here, even the liberal Fourth Circuit concluded that this doesn't violate the First Amendment. But the judge who wrote the opinion, the chief judge, had to apologize to his liberal friends for following the law. And so he said in the concurring opinion, so he had this long opinion on behalf of the court, and then he concurred in just a short, page, half a page. And he said, for those disappointed by the outcome, I say this: follow the law, continue your critical work, keep the faith, and depend on the Constitution, which remains a beacon amid the tumult. What the actual heck is this?
Keep the faith. Is this not what Twitter is for? I don't understand why he had to do this in a concurring opinion. Just text your friends. I don't know. I mean,
He was so scared about the backlash he was going to get from his liberal friends. He was like, no, I need to have this ready to go.
Wait, Grace, this is a brilliant idea. So I'm already digging into this. Some of my friends think I'm crazy for thinking judges should be openly political outside the realm of the courts. Again, Ketanji Brown Jackson could go laugh at ICE jokes.
Well, right now it's just unbalanced. She can do that, but the conservative justice can't do anything.
The asymmetry is the problem,
exactly.
right? It's the double standard that's the problem. But what if we went further and said, why don't they all get X accounts? Why don't they all get Twitter accounts or Blue Sky accounts?
And we actually had any of these dumb concurring opinions.
Post your thoughts there, as long as you keep it out of your opinion. I don't know. That's probably a crazy idea.
I want to see Clarence Thomas on X.
Should not,
my gosh.
They should not.
Please.
Okay, so maybe that's too far, even for me. But like again, imagine if a conservative judge did anything remotely like this, said, the Biden administration was just like letting in a flood of immigrants, ignoring the statutes that said shall detain, a different part of the statute, which we'll get into. And suppose the conservative judges said, well, we think the Biden administration is allowed to open the border this way, but how terrible of a policy, and we hope they lose in the next election, and conservatives keep the faith. I mean, it would be utterly insane. It's this utter double standard, Kathryn, that you identified.
And it's not their role to give their opinions, right? It's their role to judge whether or not it's following the law. So the idea that they feel like they should give their opinions at all is completely wrong.
That's exactly right. And so they issue judicial opinions. That's very different from from issuing political opinions.
Sure.
As I'm gonna die on this hill. Judges are political creatures. They can have political opinions, but that's not the same thing as issuing a judicial opinion. Those are just two different things, right? Keep your politics out of your judicial opinion, but go to the Grammys if you want, and if it makes you feel better.
That's inspirational. Well, we got to keep moving because we have our lightning round is not going as lightning as it should. So let's move on. The SAVE Act is something I wanted to talk about. We've all been hearing about it a lot in the news. It would require voters to show an ID to prove citizenship when registering to vote for a federal election. It also requires states to establish a program to remove non-citizens from their existing voter rolls. My first question is this constitutional? I thought elections were run completely by the states. That was my understanding. And the federal government was not to get involved whatsoever. But then we look at who's on what side of this issue. It's Republicans who are backing this issue. And to me, it seems like maybe this wouldn't be constitutional. What do you think?
So this is actually thank you for the layup question, by the way. I love some of the legal questions we're going to be answering today are actually quite challenging.
This one's easy?
This one's easy
because you're welcome.
If you've read the Constitution, which we all should do every once in a while, Article 1, Section 4 provides that the states basically regulate elections, but Congress may alter their regulations. So Article 1, Section 4 says the times, places, and manner of holding elections for senators and representatives. So it's actually only federal elections. And interestingly, it doesn't seem to include the Electoral College, which is kind of fascinating.
Yeah, that's
Electors.
what I was wondering.
So that's quite interesting. It says, so the times, places, and manners of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may, but need not, at any time by law make or alter such regulations, except as to the places of choosing senators, which, originally they were appointed by the state legislatures, so it's probably only,
interesting.
There was that exception. So this is purely a question of political wisdom and expediency. Which part of our elections do we want federalized? Which part of them do we not want federalized? And here, the SAVE Act, it sounds like, would just say, look, states generally can have these elections, but in this one respect, voter ID is the central thrust of the SAVE Act. Yeah. We want to nationalize election. And the interesting thing here, and I heard this actually on, I'm going to call them friends of the pod, though I don't know if they know yet of our existence, Advisory Opinions, which is another great legal podcast that you should listen to. They alerted me to the fact that a law professor published a book in 2024 arguing that we should nationalize elections. And this was when the Biden administration and Nancy Pelosi were pushing, was it HB1? Do you know what, which would have vastly expanded the federal role in election to ensure that more people are able to vote. It might have even gotten rid of voter ID, though I'm not sure if that's right in all 50 states.
Interesting.
And so he wrote this book saying we should nationalize elections. And now that President Trump and the Republicans in Congress are trying to pass voter ID, he's like, actually, I changed my mind. I don't believe in nationalizing election. And so
classic.
Yeah, it's a little politically opportunistic, but maybe it's a genuine change of heart.
Oh, probably not.
I will give him, the benefit.
No benefit of the doubt coming from Kathryn.
No, these people always do that. They just want power. Ilan.
Listen, they don't give me any benefit of the doubt when I make arguments about like birthright citizenship, which we'll talk about. So I will try to give them the benefit of the doubt. But certainly it's a nice lesson in careful what you wish for, because your side won't always be in power, right? So that's super interesting.
Well, speaking of that, there's also the filibuster issue with all of this, because this SAVE Act has passed in the House, but not in the Senate, because they have, I don't know how many Republicans exactly, it's like 54, 53, but they don't have the 60 required to get past the filibuster. So people have talked about different solutions. Trump has said, nuke the filibuster altogether, get rid of it in the Senate so that a simple majority can pass something. Other people have brought up the talking filibuster and bringing that back. I don't even know what that means. Can you explain?
Well, this obviously seems like the right answer to the filibuster question. So the problem with the filibuster as it exists today is you don't have to do anything. You just have to file like a piece of paper saying, I filibuster, and then nothing happens. Nothing happens. There's no cost to thwarting legislation.
Has it always been like that? Because I do have this conception of filibustering being like you have to stand on the Senate floor for 24 hours or something. And because there was that famous case, like the 2000s where this woman senator had like the pink tennis shoes on and she was filibustering for abortion rights or something.
Yeah.
This is like I was a liberal in high school, and this was like the most famous image burned into my brain of like, look at this hero arguing for feminism or whatever. In her little pink tennis shoes, because she was filibustering, she had to literally stand on the floor and talk for 12 hours or something like that. So is that not the case anymore? How is there a non-talking filibuster?
Right. I don't know when that changed, but it changed according to Senate rules. And now you don't actually have to go up there and talk. And so you just have to file this piece of paper. I mean, there are other famous filibusters. The Southern senators tried to filibuster the Civil Rights Act. And imagine if Strom Thurmond, whom you probably have no idea who Strom Thurmond was.
I've read a history book.
Oh, okay, good. Well, so he filibustered the Civil Rights Act of 1964. Imagine if he just had to file a slip of paper. Being, oh, no, we're not going to do the Civil Rights Act unless you can get 60 votes. No, at the time, you actually had to talk. You had to talk as long as you could, and then other senators had to come and support you. And so there's a cost to it. But if you just file a piece of paper saying, I filibuster, and unless there are 60 votes to end it, there's zero cost to filibuster. So the filibuster is an important tool preserving minority rights, but it should come at a cost. You should have to explain to the American people why you're wasting everybody's time, why you're talking, why you're reading the phone book, the cookbook, or the Bible, why this is such an important issue. And then you wouldn't filibuster everything unless it's like actually genuinely important. And, if they come and filibuster the SAVE Act, like what are they going to say about voter ID, right? I mean, it's quite popular, the polls show. So I think the talking filibuster, like bringing back that filibuster, the pink shoes example and the Strom Thurmond
example. It's a great visual.
is probably the right way to do this.
Well, and it stops the other work that they're doing, I think is crucial, because right now you can filibuster a bill and then they kind of ignore it. If you were talking and you couldn't get any other work done, it would make it a much more urgent matter.
Exactly right. So the other senators are like, okay, moving on, right?
Yeah.
You file a slip of paper, but you can't do that if someone is occupying the Senate floor.
All right, let's go to our last lightning topic. Gavin Newsom sought to prohibit federal agents from wearing face masks, you might remember, which is ironic since only a few short years ago, California had mask requirements at the beach, actually, during COVID. So
times have changed.
Yeah, times have changed. As you'll recall, this was a big talking point on the left. They were calling ICE secret police, things like that, of course, invoking images of Nazi Germany, as they love to do. But just recently, a California federal judge ruled that this mask ban was unconstitutional. Pretty cool. What do you have to say about that?
So this is actually a trickier issue than most people realize. We've talked on the show about the supremacy clause of Article 6 of the Constitution. So federal law is supreme over contrary state law and displaces contrary state law. But there's no federal law on the books that requires the use of masks or even that allows the use of masks. There's no federal law on this question. So does the state law conflict with a federal law? Well, no, not exactly. But the analysis doesn't stop there. So there's a famous case that all my former students will know, McCulloch against Maryland, where there was a big debate in the early republic about whether Congress had the power to create a national bank, the Bank of the United States, a kind of precursor to the Federal Reserve, except not exactly. The agrarians and the Southerners really distrusted the national bank. They distrusted financiers and the merchant classes. And so they lost that debate. But then Maryland said, well, we're going to tax the bank. Well, that could be hugely problematic. So Chief Justice Marshall, in a famous opinion, said the power to tax is the power to destroy. And although it doesn't conflict directly with any particular federal law, it clearly conflicts with the existence of the bank, which is authorized by federal law. And in
just really quick, the power to tax is the power to destroy. I need that on a pillow or something.
I was just thinking
like a
that is like the best
little,
quote ever.
You know, what is
frame
it
that for the show.
What is it that the libertarians say? Taxation is theft?
Taxation is theft. Yes.
That Marshall's would be much better, right?
Yeah.
Taxation is destruction. Well, that doesn't ring as the
power
power to
to
tax is the
tax
power.
is
power to destroy is so much cooler.
And then people will think you're so erudite, right? Because oh, you've read a Chief Justice Marshall opinion. So anyway, from McCulloch v. Maryland, the question now is, does the state law directly regulate the federal government in some way or interfere with them or discriminate against them in some way? Because it's obviously the case that federal law enforcement officers have to follow generally applicable laws. Like you have to follow the traffic laws. You have to follow the state's murder laws, right? So generally applicable laws apply to federal officers. And the question is this mask rule, this anti-mask? No. Who's anti-mask now? I can't remember.
Want them. No.
California is
does
anti-mask.
not want masks. They're anti-mask.
They don't want masks.
Because with the masks, they're the secret police.
Correct.
Right.
Okay.
We have to know who the federal agents are. Okay.
So I'm just, I'm still in COVID, my mind, anti-maskers is totally the opposite.
They have no morals, so it's hard to follow,
It's hard to follow which way you go. Now look, in an ideal universe, right? In an ideal universe, law enforcement should not be masked. I mean, that's obvious to everybody. Like there are serious risks to individual liberty. There's serious risks of government tyranny with masking. But we all live in this timeline, not in alternative peachier timeline, right? And in this timeline, states are attempting to interfere and thwart the execution of federal law. You have private individuals trying to thwart the execution of federal law and to dox these officers
and attack them.
And to attack them. And the states are at pains to do anything about it. And in that context, is this law an attempt to directly regulate and interfere? Probably. In this case, at least in this fact intent specific context, in this case, the California judge actually held that it was not a direct regulation, but because the mask mandate, anti-mask mandate. It's an it's an anti-mask mandate.
Mask ban.
Exempted state officers that it was discriminating against the federal government. And so
interesting.
That was this ruling. Now, it did apply to local officers, like local police departments, but not to like CHP, like Highway Patrol.
So odd.
So I actually don't know what the higher courts will do with this, but it'll be super interesting to follow.
Wow.
Okay, well, to our listeners, that lightning round was not quite lightning, but, there's
a lot of news to cover.
And drop us a comment, right? And of course, follow, like, subscribe, all of that. Drop us a comment. Let us know if you appreciated the more comprehensive coverage of some of the legal things that are going on, or if you just want us to dive in right to the juicy, meatier stuff right away.
Speaking of our first juicier, meatier item, habeas corpus. This was going actually originally to be part of this little legal lightning round that we did, but there was a major development in the last week that we felt like we need to take the time to break down properly. Early last week, a judge in Texas, as you probably saw online, ordered 5-year-old Liam Conejo Arias and his father, Adrian Conejo Arias, back home to Minneapolis. They were riding on the plane. The little boy was up in the cockpit. It was adorable. But,
And he was not on the Super Bowl halftime show.
Yes, that has been disproven.
You got had by the fake news, which I may or may not have.
Which would have been very cute.
Yeah. It would have been cute.
Anyway, the order that this judge put out cites the Bible. It quoted the Declaration of Independence. It called the government incompetent and its immigration program, quote, ill-conceived. It was a beast. It was a beast of an opinion. But what it seemed to be lacking, it had all that, political points. What it did not have was any citation to legal authorities. It didn't cite any statutes. It didn't cite any cases. And yet the left is very much celebrating this decision, it seems, as though it's something to be emulated and repeated over and over again. So to me, that seems dangerous, that to be celebrating a decision that essentially has no legal basis or appeal to authority.
Yeah, former President Barack Obama posted on X this article from the New York Times that says, in under 500 words, a judge weaponized wit to free the child detained by ICE.
I'm all for weaponizing wit. I'm not sure that's what the judge did. I'm also for law, by the way, and explaining legal reasoning.
Right. Pro-law, yeah.
And Obama says, here's a useful reminder of what our federal courts should be doing to uphold our constitutional traditions. WTF.
Yes. So I think we should just luxuriate on this for a second. The New York Times literally took an opinion that cited no law, that quoted the Declaration of Independence, which didn't even seem particularly applicable, that quoted some Bible verses, which, by the way, are I didn't realize judges were allowed. Isn't that like establishment, or at least that's what they say, right?
The left is always up in arms because some judge somewhere wants to put the 10 Commandments on his wall, and they're like, no, this is awful.
So imagine if what I like to remind people of is Judge Jerry Smith. Full disclosure, he is the judge that I clerked for, the Fifth Circuit, when he issued that scathing dissent in the redistricting case because the two other judges on the panel issued their opinion before he wrote his dissent. And yes, he made some statements that people have interpreted to be political, but they said, this isn't judicial. How dare Judge Smith do this? It's unbecoming of a judge. One professor whom I was speaking with in Texas shortly after that said, oh, his reputation is really going to take a hit from this. What do you all think about this judge's opinion that had no law whatsoever? At least Judge Smith's opinion had law, and the Supreme Court seems to have agreed with it. Because they stayed the panel's decision. So they seem to agree with Judge Smith's dissent. At least Judge Smith's dissent had a bunch of law in it. This has no law whatsoever. And what is the New York Times doing this glowing piece? And Obama, this is what judges should be doing, right? Which led the Rationally Based Pod on X to retweet and say, what? Issuing opinions with no law? It's that's what we should be doing? Thanks, President Obama. Really, really perceptive. And so again, it's one of these things. You can be political, but keep your politics out of your judicial opinions. I'm all for legal reasoning all the way down.
To the point of his reputation, if that's how, President Obama and the New York Times are trying to frame it, and they love it, obviously. But what about other lawyers? What about his peers? How are they going to react to this?
I don't, again, it's this asymmetry that Kathryn sort of mentioned before, right? It's their peers are going to react the same way because there seems to be an exemption if you're non-legal opinions, if your political statements in your judicial opinions just arrive at the correct results and say the right buzzwords and strikes the right tone from the liberal perspective, then you're all going to be celebrated, right? I mean, there are people on the right who didn't criticize Jerry Smith's opinion for being a little too political and a little too over the top. And I don't know if that's true of his opinion, but you can make an argument about that. Who said, yes, I agree, both are bad. Both are bad. Has anybody on the left said both are bad? I don't know. Now, I'm not on Blue Sky. I mean, I lurk, but maybe there's somebody on Blue Sky that was like, oh yeah, this is a bad opinion. I highly doubt it.
Did you also notice? Well, first a question for you. Are people often dragging pictures into the Word documents? Did you see he had a little picture? Is that a common practice?
It depends. Is it an exhibit? Was it an exhibit, or did he just pull?
No. He pulled it off of the interwebs and just dropped it in a little picture of the child.
It was the boy in the hat, right? That famous.
Well, I'm all for. It's rare, but you can do it. There was one dissenting judge, or maybe it wasn't a dissenting judge, but in the Ninth Circuit that did a YouTube video with his dissent because he wanted to explain how firearms worked. So there's some disagreement, about that. And I actually just saw a paper was posted by, I think it was maybe not law professors, but two independent scholars who were like, we should disseminate this genre. This is a good genre. Judges have always used sort of visual clues to their opinion. So I actually don't know. But there's apparently a scholarly discussion now going on about whether judges can issue YouTube videos.
That's interesting. One other thing that you may or may not have noticed is the judge signed and dated the document as being February 31st, 2026.
I've misdated documents that I filed in court.
Sympathetic.
So, it's
I recently... That date doesn't exist.
But that has to be intentional.
Yeah. That's fair. I have recently filed something in court because I still practice a little bit where I said it's 2025. Obviously not true. Not quite as bad as, say, February 31.
But you can understand your line of logic there.
Yeah.
I mean, I don't understand the date.
He committed more grievous errors than that, I think.
The
dates I think are forgivable.
Is it just cheeky? I mean,
but listen, get them while they're down. Let's bring up everything you got wrong while we're at it.
But one last point on this, because it ties into the Fifth Circuit ruling, which I know we were going to talk about now, is we don't know if he's right or wrong. It's just emotional. We don't know if he is right or wrong on the law. What is the law? What is, the rule of habeas corpus that's going on here? Are they entitled to habeas relief, or are they not? Or were they rightfully detained, or were they not? We actually don't know because he didn't cite any law.
Right.
Well, now we actually know because the Fifth Circuit issued a ruling saying such individuals can in fact be detained.
Because the case that brought Liam and his father home, that was a habeas corpus petition, correct?
Yes.
And that was pre this new Fifth Circuit ruling.
Correct.
So can we just pause for a minute? Because I know habeas corpus has to do with being wrongfully detained. It means of the body in Latin or something like that. But can you just, this is such a hot issue, especially here where we are in Minnesota, because our courts right now are getting flooded. There have been like 700 to 800 of these habeas corpus petitions filed just from January 1 until now. And in a normal year, there's like, did we look it up? It's like 17 in a full calendar year. Yeah. It's like nothing. So And each habeas corpus petition has the goal of releasing, a detained illegal immigrant. Can you just walk me through, in simple layman's terms, what habeas corpus petition typically looks like?
Yeah, so I can walk you through it in Latin. Is that no?
No,
so, okay.
Not helpful.
No. I'm not being serious. So habeas corpus means like having the body. So it is the writ of habeas corpus is called the Great Writ sometimes, and it is this legal writ that you can file when the government has somebody in custody that requires the government, the executive, to produce the body in court to justify the detention. And so that's why it's called habeas corpus, depending on if you're anglicizing it or not. Let's anglicize it. This is America. Habeas. Okay.
There's some things you have to just.
Or not? Is that
I got made fun of in law school. I remember the day I said habeas corpus, and people looked at me like, habeas? Like, isn't that how you say it?
There's some things you got to mispronounce just for the sake of like
anglicized Latin.
Normalcy
is apparently habeas corpus, and so. Now, the reason that we have this flood of habeas corpus petitions in Minnesota and elsewhere is because of the subject matter of this Fifth Circuit ruling. Until about 6 months ago, the government maintained that if you were an alien unlawfully present in the United States, so you evaded entry, so you evaded inspection, but you've been living in the United States, that you were entitled to be released if you're caught. You're entitled to be released pending removal proceedings or deportation proceedings. And 6 months ago, the Trump administration said, no, actually, we're not going to do that. We interpret the statute differently.
Is this also called catch and release?
This might be called catch and release.
I think it's basically the same concept anyway,
yes.
Which never made sense to me because what would happen is then the illegal immigrant would never show up to court. There was nothing forcing them to go to their court date. They would just continue to evade.
Which is part of why we have such a huge population of illegal immigrants in America, because they would have these touch points with authorities, but then they would get released and then they'd just never show up. And that's part of why the issue ballooned so much in recent years.
Right. And in the Fifth Circuit opinion, the judge mentioned that in 1996, when they were enacting the Immigration Reform Act, they pointed out that something like 90% of those who are caught and then released on bond never show up again or something like that, which is
insane.
Which is very interesting.
And that makes sense. I mean, really, logically, as the person who's here, they're already here illegally. Like, they're not afraid of breaking another law while they're at it. Law of self-preservation, I'm not going to show up to my court date.
But on the point of the 800, so as a result of this change in policy, and we've had all these detentions of aliens present in the country who evaded inspection, who all of a sudden were being, detained, and they were filing these habeas petitions and absolutely flooding the courts. A friend of the pod here in Minnesota has called it on X habeas corpus chaos, which is, look, if they're entitled to be released, that absolutely makes sense. The Fifth Circuit says no, and so we'll dive into that. But there's no question that the policy of detention, if habeas corpus is available to all these individuals, it would absolutely flood the courts and create this big problem, right? There was this whole big to-do with the Trump administration supposedly violating a bunch of court orders, including here in Minnesota. Most of them are habeas orders. Well, the Fifth Circuit just ruled that they're actually not entitled to habeas corpus, that they are entitled to be detained. And this ruling created a huge uproar in the parts of the legal community, blue sky legal community, and not just blue sky. I mean, it's a really tough issue, and so
well, it caused a lot of the strife here in Minnesota between judges on the federal court and the feds. Right, they were kind of at odds because there were so many of these habeas corpus petitions that my understanding was the lawyers for the federal government just really couldn't keep up. And in addition, the judges for their side were putting deadlines on their responses of like immediately or 1 day from now, or these incredibly short deadlines saying they need to address these things right away. That was just unrealistic, so the federal government could not keep up. So this is huge for their case, obviously.
Yeah, and so the Fifth Circuit ruled in a 2-to-1 opinion that the Trump administration is right, that not only may they detain these aliens, but they are required under the statute to detain them, which is what caused this huge kind of shock in the legal community. And everyone says, "Oh, how dare they? You know, they're violating clearly established law and historical precedent." And the one takeaway I have from actually taking a deep dive into this sort of area of law and the judicial opinions is that anybody who says this is an easy issue is fooling you. It's fooling you. You're just being a partisan hack if you think this is an easy issue. If I were a betting person, I would bet the Supreme Court upholds the Fifth Circuit decision by a very narrow vote, but it also could go the other way. So it's not at all obvious. So why is this so difficult? Okay, so go back to 1996. I was around, kind of. I think I was like in fourth grade,
year.
third grade. I don't know. Yeah, that's right. The immigration laws that existed at the time distinguished between aliens who were arriving either at a port of entry or not at a port of entry, but who are caught. So they're arriving aliens, and those who evade detection. Right?
They just slip in.
They slip in, they evade detection. Some of them might have lived for 6 months, 2 years, 10 years, 20 years. And the immigration laws as they existed, as far as I understand it, this is not my area of expertise, immigration laws. And it's actually very complicated, like the thicket of immigration law history. It treated individuals who had managed to evade detection much better than those who were caught at the border. So those who were caught at the border could be removed more quickly. There were sort of these expedited proceedings. And if you were caught in the interior of the country having evaded entry, you had a lot more procedural rights.
That's so backwards.
It struck a lot of people as backward. And so the idea of the 1996 I don't even know exactly like how people say it. IRIRA. It's the Illegal Immigration Reform and Immigrant Responsibility Act. IIRIRA. So maybe that's what they say. The idea was to diminish the differences between these two groups of individuals because it was unfair.
Which seems logical.
It seems logical. It was this sort of moral hazard. And
it incentivizes people to evade capture upon entry.
Exactly. Well, presumably everybody's incentivized to evade capture.
That's true. No, that's true. I said that.
It rewarded those who successfully evaded, right?
Yes.
And so Congress and Bill Clinton, remember back in the day, Bill Clinton, era of big government's over, era of illegal immigration's over. I mean, it's
wild.
Times have changed. Times have changed. Signed this law that defined these two groups to be similar. So it defines in the statute an applicant for admission to be either somebody who is an arriving alien at a port or the border, whether a port or not, or somebody who is present in the United States without having been admitted.
Okay.
So it basically captures all of them. If you try to come illegally, if you're an arriving alien, if you are caught, if you are not caught, if you're caught 20 years later, it was supposed to treat all of them the same. They're all applicants for admission. They all now get similar removal processes and deportation processes. So the advantages of escaping and undetected are not rewarded right anymore. So the advantages are supposed to disappear. But there's a question as to whether those advantages entirely disappeared.
That seems so clear cut when you describe it. Like, what's difficult about this?
That's a good question. The Fifth Circuit majority said the point of the statute was to eliminate these differences. And one of the differences on the statute is it's quite clear to everybody that arriving aliens are subject to mandatory detention until their status is determined. So you come here, you arrive at a port of entry, or you're caught at the border, you shall be detained. You're an arriving alien.
Makes sense to me.
And nobody doubts that. But the question is, the other applicants for admission, those who are living in the interior, again, some might have been there 20 years, 25 years, are they subject to mandatory detention when they're caught? Mm-hmm. Or because maybe they've lived in the United States for 20 years, are we going to release them back into the country? And so this is the question, and it's actually quite difficult under the statute. So again, we mentioned that applicants for admission include both the arriving aliens and those who are present without admission. And by the way, actually, one small detour, if I may, like, why is this so important? When you look at the statute, it does seem like that the president has discretion to detain them, even if it's not mandatory. But so there's another part of the statute that says the president, that doesn't apply to mandatory detention. There's this other part of the statute that says the president may detain or may release. Well, that sounds like you don't have to if you don't want to. Mm-hmm. So what's the big deal? What's the big deal? Well, it turns out there's a regulation that says we're going to presume they get bond hearings. There's some Supreme Court precedent that says, well, if it says may detain, there's an implicit time limit. Kathryn's giving me the look of disbelief.
It's
The
just
implicit time limit is insane.
we already do this with people who are accused of a crime. We detain them until they get their trial. There's innocent people that are detained all the time for a year or two while you're waiting to go to trial and prove your innocence. So I don't understand why this would be so much different. You're committing a crime in our country. Yeah, you got to be detained until you go and, go to a hearing.
Yeah, and look, the statute seems to allow them to do that. But look, it's not totally crazy, the Supreme Court rulings. So in the Supreme Court rulings emerged in those situations where someone has been detained for like 10 years. Why have you been detained for 10 years, or not quite 10 years, but why have you been detained for so many years? Well, because the countries who are trying to deport you aren't taking you. They don't want to take you. It's like, what are we supposed to do?
Whoa.
And the court said you have to release them into the country, which is kind of
Man,
interesting.
that's so frustrating.
We sort of absorb. So it's like, it's obviously true that like you shouldn't be able, where it says, may detain, or even where it says shall detain, it's for the purpose of removal, right? To get them out of the country. And so it's obviously true that you shouldn't be able to say, well, we're going to detain you, and maybe in 10 years we'll issue removal proceedings. Now, the statute actually requires removal proceedings within 90 days. But of course, there are various reasons it doesn't always happen that way. Anyway, the point is, if the Trump administration is correct that the statute requires that they be detained, then you don't have to worry about the Supreme Court case law. You don't have to worry about that regulation, about the may and the time limits and so on. It says shall detain. We have to detain them. And so that's what the Fifth Circuit concluded, that they were right, that they shall be detained. They have to be detained. But the statute's hard to read. It kind of goes both directions. I know I've been talking a lot, so let me just show you the statutory language. So again, applicants for admission include both arriving aliens and those present without admission. Then there's a part of the statute that says if you're an arriving alien, we will detain you or remove you. But if you meet certain criteria. And then there's another part of the statute that says other aliens may also be detained. And the question is, when it says these other aliens, does it refer only to arriving aliens? Is the whole part about just arriving aliens? Or does it also include aliens present without permission? So what the statute says is, in the case of an alien who is an applicant for admission, which counts both arriving and those present, right? In the case of an alien who's an applicant for admission, if the examining officer determines that an alien seeking admission is not clearly and beyond doubt entitled to be admitted, the alien shall be detained. And so the question here is, well, wait a minute. Does this refer to all applicants for admission, or only applicants for admission who are also seeking admission?
This is insane.
And are
I'm
those
sorry.
two different things?
To me, an applicant for admission obviously means that you are also seeking admission. I mean, am I crazy? This feels like people splitting hairs.
Which
I guess is lost, so,
You would do well. Didn't I compliment you last time and I said you would be a great Supreme Court justice? You would also be a great Fifth Circuit judge.
Thank you.
You would be a great Fifth Circuit judge.
What about me?
Because, well, Grace,
Single
in that
tear
case,
going
down. Actually, Kathryn, you might be just radical enough for the Fifth Circuit.
I have something radical to say also, which is that this whole conversation makes me think that Trump's border wall was actually so genius. These people, we can't let them into the country to begin with, because now we are dealing with all of these laws and detaining them. And yet I don't want us to be in the business of detaining someone who's here illegally for 10 years. That's crazy. But if there's nowhere else for them to go, I mean, we just need a huge wall and they can't get through. I mean, that's not the only way people get here, of course, but it seems like that's the solution, is stop people where they're trying to come in.
Yes, because letting people come in illegally and establishing lives here and then ripping them out is not at all the kind or compassionate thing to do.
No, it's sad. It's absolutely sad. And I understand why people get, they don't like seeing the images of people being deported, pulled out of their homes where they've been for a long time. But it's not the result of, the Trump administration. It's a result of the administrations that just let them live and carry on a life here illegally for a long time, knowing that at some point we're going to have to enforce the law.
It was the result of the Bush administration, because they liked, anyway, I don't want to get into the politics of the 2000s again. But yeah.
Frustrating.
I think that political analysis strikes me as exactly right. Like, we're not unsympathetic to this problem. You've lived here 25 years, including in the Fifth Circuit case, 20 years, 25 years. But if the border had been secured, which was what was, promised all along, then we wouldn't be in this situation. But look, so on the legal merits, Grace, as you said, it's actually what the Fifth Circuit basically said. which was an applicant for admission is necessarily seeking admission. The whole point of the statute was to define both aliens present without admission and those arriving as seeking admission. Now there's other clues going the other direction. So the dissent points out that the word admission is lawful admission. It's defined as lawful entry under the statute.
Okay.
So if you're seeking admission, must you be seeking lawful entry? But this proves too much because the statute defines those who evade entry as applicants for admission. Well, if they're applicants for admission, then it treats them as applicants for lawful entry,
right?
Even if they are evading the border.
Already entered.
so that doesn't quite work. Now, look. The dissent points out there's another part of the statute that deals specifically with mandatory detention of certain inadmissible aliens. And wouldn't that part of the statute be redundant? And look, maybe a little bit. And the Fifth Circuit says, yes, maybe a little bit, but the two provisions do slightly different work. So one is if we know you're inadmissible, then we'll detain you. The other captures a broader category of persons. If we're unsure, if you're not clearly entitled to be admissible, the other provision of the statute also covers deportable aliens who have been admitted, but who then commit crimes. So like they both do different work, but there is substantial overlap, right? Which does create some suggestion that the statute isn't carefully written, or it is not a paragon of clarity, as I sometimes
like
tell.
all laws. I mean, the people who write our laws are just not that intelligent. That's one thing I've learned living in Minnesota and seeing the process go through in our state in particular. And I'm sure it's true at the federal level too, that the people who write these laws are not always writing them in the best way, and they create all kinds of legal questions and messes.
To the point of living in Minnesota, so this was a Fifth Circuit court decision.
Yes.
Does this, I presume, not affect us living here in Minnesota in the Eighth Circuit?
So technically, that's correct. So Liam, the case that we started with, where that judge made that ridiculous 2-page non-law ruling, he was, I think, detained in Minnesota and very quickly transferred to Texas.
Mm-hmm. Oh,
so
Fifth Circuit.
Right, which is in the Fifth Circuit. So the Fifth Circuit, thank you for reminding me to clarify, covers Texas, Mississippi, and Louisiana. And there are lots of immigration detention centers in Texas and Louisiana because those are border states. So if someone is detained in Minnesota and manages to file a habeas petition before they're transferred, then I don't think the Fifth Circuit ruling binds them. Okay. But, I would put a lot of money on like the administration putting in place processes to ensure that detained individuals make it to Texas quickly. That's probably what they would do. Either way, this is probably destined to the Supreme Court, and so it will.
And if it makes its way to the Supreme Court and the ruling sides with the Fifth Circuit's decision, then it would affect everyone in the country. Correct.
And there will be the end of the habeas corpus chaos that the sort of friend of the pod has pointed out. I will say one other point in favor of the dissent in this case, because this is the rationally based podcast. And you know what I think is based? Actually trying to understand the other side's argument about things.
I don't
Is that not
know.
based?
I think that's rational.
Am I squishy?
That's rational.
Okay, so the rational part of the podcast, let's actually examine the dissenting opinion here. They point out, and a lot of scholars have pointed out, that the government has interpreted the statute for 30 years since it was enacted to allow bond hearings. So to not apply the mandatory detention to aliens present without admission. And so there's a canon of statutory interpretation. My students who are listening, exam preparation, called the long-standing and contemporaneous interpretations canon. There's a Latin word for it, which I won't say on this podcast, partly because I don't know exactly how to say one of the words, but it basically stands for the proposition that, look, if the executive branch interprets its statutory authorities in a certain way, contemporaneous with the enactment of the statute, and it's been longstanding, then that is some evidence that everybody understood the statute to mean that. Mm-hmm. And I really like this canon of interpretation because it's a good gut check. Because like as a judge reading the statute, you might think something. But the fact that for 30 years, smart people tasked with administering the statute thought something else actually is like a good gut check. Like, oh, maybe I'm wrong about the statute. And so they do have that. The dissent has that going for it. But Judge Edith Jones' opinion for the Fifth Circuit says, well, look, when you look carefully at the regulations, they didn't say they didn't have the authority to detain them. They just said that in their discretion, they're going to not exercise that full authority. Right. But still, it's one of the better arguments on the side of the dissent. So bottom line, anybody who thinks this is an easy case is absolutely fooling you. Again, I think probably the Supreme Court upholds this in a very close vote. I don't think all the Republican-appointed judges are going to side with the Fifth Circuit, but I think probably 5 will. So there's a chance 1 will peel off, maybe 2. And so it's going to be 5-4, one way or the other, because it's a close case. It's a close case.
I don't
Anyone
see
who
that.
tells you
I don't
otherwise,
feel like it's that close. I feel like you've laid out all the arguments, and I am so on the side of they obviously are able to detain.
well, that was the legislative intent, right? Is to treat them equally. But again, there is a different, as you said earlier, there's something different, feels different about allowing somebody. It's one thing if you secure the border, but if you don't secure the border and then they build a life here for 20 years, it does feel different. On the other hand, Congress did intend to collapse the distinction between the two groups. So, I don't know.
We had years of either squishy or horrible presidents, and now we've gotten to here. I mean, that's not a good standard for precedent. Oh, we have to do what those evil and or just squishy presidents were doing. Like, that doesn't mean they were correct.
That's a great point, actually. What I'm taking away from this discussion is we need updated immigration laws, because all of this is so dated, and these statutes were written when we did not have the massive illegal immigration issue that we do today. It's just reached a scale, and we're splitting hairs over these terms that don't even apply well to the situation that we're dealing with today.
That's so true. Like, I think they didn't realize that we would have, presidents who want to weaponize illegal immigration to help them build voting blocks within the country. You know, like, that's just, could the person writing this law really think that that was what was going to happen? I don't know.
We are really bumping up against our time here, and we are dangerously close to not getting to the topic we've been promising you guys for a couple weeks now. Birthright citizenship.
We do have to do a dedicated episode to that. And I think we'll maybe just do it off our schedule and have like a bonus episode. Okay. So subscribe and, follow for that. But there is, as Kathryn said at the beginning, lots to talk about. And, we've got oral argument coming up. We'll get the opinions coming out. We'll get other briefs coming out. And so there'll be lots of opportunities to talk about this. But
we have on the Rationally Based Pod the foremost expert on the issue. So we have to talk about it at length. And it is so interesting because I think everything I thought about this issue was kind of wrong after learning more about it, which is interesting. So we'll definitely keep people up to date. And it's a case that's kind of moving forward right now, right? The Supreme Court has agreed they're going to take it on. So as it goes along, we can keep doing updates too.
Yeah. Do you want to give us maybe just a 2 or 3 minute update? What do our listeners need to know this week? I mean, I know there were developments literally yesterday as we were prepping this episode.
Yes. So the development. So first, I wrote an amicus brief in support of the Trump administration.
And then just really briefly, an amicus brief is when it means friend of the court, right? I know this.
Yes,
and so you file information to help them decide a case. Correct? Am I getting anything wrong here yet? Okay.
Yes.
Are there limits on who can file an amicus brief? Like, could I file one? This is what I don't understand. Who is qualified to file one?
That is a great question. Historically, the rule at the Supreme Court was that you needed the consent of the parties to file an amicus brief, or
each of the parties in the case.
Correct.
Okay.
Or leave of the court.
Okay.
They have changed the rules to allow anybody to file an amicus brief.
We could. Oh my God, Q! Let's file an amicus brief.
But I caution against that. First of all, it's expensive.
He's like, you will embarrass the podcast.
I would edit it for you and make sure you're not totally crazy.
Oh, thank you.
But it's very expensive. Not the filing fee, but there are certain printing requirements. You have to get 40 copies. They have to be the right color, the right font, and you have to pay printers to do this, and it can cost thousands of dollars. So it's expensive. And you do have to, at the beginning, to explain your interest as an amicus of the court. So why is it that the court should value what you have to say? What is your interest in this particular case?
I am an American citizen. I am interested.
Actually, I actually don't know if that would be enough. It might be. So I have to investigate that. So,
oh my gosh, I did not mean to derail us this much.
No. So anyway, I wrote an amicus brief. I also wrote a 135-page paper on the question of birthright citizenship that is coming out today. We're recording Tuesday. I know the pod comes out Thursday, but so you will have the advantage of it. It's coming out today in the Harvard Journal of Law and Public Policy, along with 2 other articles on birthright citizenship and an introduction from Judge Stephen Menashe of the U.S. Court of Appeals for the Second Circuit, one of the most prestigious circuits. And this is huge because one of the problems with the Supreme Court granting certiorari in this case, which is review. Okay, Kathryn, sorry. I know it's another, I think that's probably also Latin. The granting discretionary review of the case.
Okay, thank you.
How do you spell it is even more tricky. But so they granted certiorari in the case, but without any without very much percolation in the circuit courts. We don't have a single circuit judge on the merits taking the Trump administration's side. There was a judge in the Ninth Circuit who dissented from one of the Birthright cases by saying that the states didn't actually have standing to sue. But he didn't address the merits of the question. So we don't have very much percolation. And so a lot of people think maybe the Supreme Court should have waited another year before taking this case. But they took the case. And I think it's a huge deal that a U.S. Court of Appeals for the Second Circuit, based in New York, a federal judge on a court of appeals in the Second Circuit writes this introduction to this volume saying this is a legitimate debate. This is a real, genuine debate. And don't be too quick to dismiss the Trump administration's arguments. And so that is kind of an interesting legal development that we now have a Second Circuit judge on record not supporting the Trump administration, but suggesting quite strongly that there's a there. There's actually quite a bit of evidence there. So that's sort of the legal development. Now, what is my paper about and what is my amicus brief about? And then I promise our listeners, we will take a deep dive into this because you have demanded it, and we will do it.
But you can go read the 135 pages. I will be waiting for the deep dive that we do. But
it's actually riveting.
It's out there.
It's actually riveting.
I think
Says
it's
the law
riveting.
professor.
I don't know. I think my writing has a nice cadence to it. But
I'm sure. I'm sure. I'm still going to wait for the show.
I appreciate the confidence. But so the 14th Amendment says persons born subject to the jurisdiction of the United States are citizens. And the question is, what does subject to the jurisdiction mean? And we will get into that in a future episode. But a lot of people think, and I think correctly, that it largely, the framers of the 14th Amendment largely intended to constitutionalize the common law of birthright citizenship. This history of birthright subjecthood or subjectship at common law in England, from the 15th, 16th, 17th, 18th century. And the conventional view here is that anybody born on the king's soil was, by virtue of being born on the king's soil, a subject of the king's by birth. But that's not actually what the sources say. And this is sort of the theme of my article. So everybody accepts that ambassadors' children are exempted. Why? They're born on the king's soil. They're born on American soil. Invading armies. Any child born to a soldier in an invading army is also exempted. Why? And
if you're on a base in a different country, you're also exempted, right?
It's as if you're born on the soil, right? That's a difficult question. Oh. Because the question there is, so yes, but is that a matter of common law, or have the statutes extended the rule?
Sure.
And so that's super interesting. Okay. But at common law, the king's ambassadors abroad were understood to be, so their children were birthright subjects of the king who sent them.
So it's not as simple as you're born on a country's soil, Correct. You are automatically a citizen.
Exactly. The actual test is you have to be born under the protection of the king. And not just that, you have to be born to parents who are under the king's protection. So why are ambassadors' children exempted? The ambassador is not born under the king's protection and within the king's allegiance. And a foreign invader is not under the king's protection and under the king's allegiance. Why do I mention allegiance? Because this was sort of a mutual compact. A alien could come into the realm and exchange allegiance, give the king a temporary allegiance while the alien is in the realm in exchange for a temporary protection. Okay. And so their children, right, of aliens who came lawfully with the king's permission, who were under the king's protection, they were understood to be subjects of the king temporarily while in the realm, such that their children were natural-born subjects. So aliens could qualify for this rule, but ambassadors could not, and foreign soldiers, invading armies, could not. So now there's a question, what about illegal aliens? The alien had come contrary to the laws of the realm.
Right.
Would that alien be under the protection of the king? Because again, the protection comes from this exchange of allegiance and protection. The king will protect you, but you obey the sovereign's laws. And what I try to show in my scholarship is that actually to be put under the king's protection in common law required the king's express permission in what was called a safe conduct. Okay, so we have these grants of safe conduct to merchants from other countries in 1157 and in 1307 and throughout the 12th, 13th, 14th centuries, saying you may come here, and so you have my permission to come to the realm, and we take you under our protection.
Sure.
The royal protection.
And that's with the sovereign's permission.
The sovereign's consent. So in this document, not only it gave consent to enter, but extended the king's protection. Now, eventually, safe conducts fell out of use. Safe conducts were relevant only to aliens who were from countries at war with England, but generally friendly aliens from friendly countries, aliens in amity, could come to the realm and were understood to be under the king's protection. Why? Because the statutes provided for that protection. So Magna Carta, the Great Charter, the 1297 version says alien merchants shall have safe and secure conduct, shall have safe passage, shall have the king's protection, unless they have been previously or publicly forbidden. What does that tell you? If you're forbidden from entering, you're not under the king's protection. You don't have safe conduct. There's a statute from the reign of Edward III in 1353 that says merchant strangers may safely and surely and under our protection come and dwell in our said realm. So what I've shown is for aliens to be under the protection for purposes of the birthright rule, right, such that their children would be birthright subjects, that required the king's consent or parliament's consent in statute. Now, does this prove that without consent, without safe conduct, without a statute, they wouldn't have been under the king's protection? It doesn't prove it, but the other side has no evidence whatsoever for the other proposition, right?
It certainly casts doubt on the proposition we've been operating under for the last 20 years.
Exactly. The other side would have to show that, okay, an alien who came without safe conduct and contrary to the laws.
Yeah. When
the laws say we don't want you here, you are like Magna Carta, previously or publicly forbidden. Would that alien be under the sovereign's protection? Is there any evidence that that would have been the case? And I am not aware of any such evidence, except in this journal, this volume of the Harvard Journal of Law and Public Policy. A law professor, Gerard Maglioka, who's a friend of mine, argues that the gypsies, which today we would call the Roma people, he argues that the gypsies were unlawfully present in England and that their children were considered birthright subjects. But I don't think that's true. I don't think that's right. I read the evidence different. Professor Maglioka relies on a statute from the reign of Queen Elizabeth that says because scruples and doubts have arisen as to the status of the children.
Okay.
Wow, scruples and doubts.
Scruples and doubts.
Podcast title at the very end, coming in hot, maybe.
Scruples and doubts. We should name this episode that. You made it all the way to the podcast title. I love that. Because of scruples and doubts, legislatively, Parliament has to decide what to do with children born in the realm to these gypsies who were prohibited from coming into England.
Right.
Gypsies were prohibited from coming into England.
This is a good comparison.
And they concluded that we're not going to remove them. We're not going to deport them. So there's a question, okay, why did scruples and doubts emerge? If the rule was so obviously anybody born under the king's soil is the king's subject, is a citizen, there wouldn't have been any scruples and doubts.
Yeah.
There wouldn't have been any scruples and doubts, but there were. And the statute does not read as if they're declaring what the common law is. If the statute isn't declaring that the rule has always been such and such and therefore they're citizen subjects, it reads like we're not sure what to do with them, so legislatively we're going to come up with a solution.
Sure.
So I don't read it the same way that Professor Maglioka does. I will say Professor Maglioka wrote a very short amicus brief in the court. He wrote it after I submitted mine. So I didn't have a chance, of course, to respond to it, which is how the timing works. But I will be responding to it in a longer reply to my critics in a future Notre Dame law review article.
Is this how you guys fight? Like you do like amicus and then law journal and then like, is this your war zone?
I'm glad you asked.
It's like diss tracks.
That's how we... That's how we should fight, right? You write an article, somebody writes a response, and you write a reply, and you can do amicus briefs on both sides of an issue. What I don't like is the absolute viciousness of the attacks that I'm getting from like Blue Sky, and professors on Blue Sky, who won't write briefs and who, are anyway. I am always happy to engage with my interlocutors on Blue Sky in good faith, and I'm happy to continue doing that. But for now, I would prefer in the law review format or in the amicus brief format. But yeah, that's why the issue is so much more complicated than people realize. And so what is the connection of the common law rule to jurisdiction? What about temporary sojourners? We had this interesting amicus brief from a national security official that was filed about the national security risks of allowing birthright citizenship for temporary visitors. And we will get into all of that in future episodes. So
yes, stay tuned. There is clearly so much to unpack on this issue, and we know you guys want to hear on it, but we are simply out of time. We are going to have to to do a fully dedicated episode or maybe a bonus special on the topic solely of birthright citizenship. But again, we just want to thank all of you so much for the feedback you're giving us on the show so far. We love hearing from you guys, and just, support the show if you're enjoying it. If you enjoyed this episode, give us a rating on whatever platform you're listening on.
Yeah, we got 1 star. I'm sure it was a lib, okay, but we need to counteract that. So head on
the
over.
assumption that you've made it this far, you're probably not a lib. And in that
therefore
case,
should
please rate us on Apple. I think that was where the 1 star was. I think we've overcome it. So thank you to all our watchers. But it does really help, especially early stages, as Grace and Kathryn have said before. And let us know what you want us to talk about next. And we will get to a longer episode about Birthright. But there's so much legal news happening, which is why we're so excited to be here with you all.
We'll see you guys next week.